Welcome to Straightforward Estate Planning with Pedrani Law.
Hey everybody, welcome to an all-new episode of Straightforward Estate Planning with Pedrani Law. I'm your host, Mike Leon. You see Keith here, and he's the founder of Pedrani Law, and he brings both a legal and business background to helping families plan ahead, providing clear, practical guidance in estate planning, probate, and Medicaid planning so you can protect your assets, secure your legacy, and have peace of mind for the future. And in today's episode, we're going to be talking about estate planning for younger families. Keith will explain why it matters and what documents are essential and how parents can make sure their children are protected if anything happens. So Keith, why don't you introduce our audience and share a little bit about your background and what led you to focus on estate planning?
Well, first of all, thanks for having me on, Mike, and I appreciate the introduction. So really my practice evolution into estate planning kind of mirrored my own life. I was blessed with twin girls, Zoe and Emma, in 2020. It's the same year I started my practice. Initially, I wasn't focused on estate planning. I was focused on lender representation and commercial transactions. I also had a few litigation matters that I took with me from the initial law firm that I was working with out of college, out of a law school rather. So it wasn't right away, but you become a new father, become a parent, and suddenly you realize this awesome responsibility, and it really it started to hit me in waves. Number one, you get them through the first 6 months, and then they're talking, they're developing personalities and things like that, and you're just so in the weeds with that, you don't really even think long term. But eventually you settle down, you start the 529 plan, and then you really start thinking in terms of if something happened to me, if something happened to my fiance, what would happen with my girls, or what would happen with my children. And so I started having to answer those questions for myself. And as an attorney, it was a little bit more accessible to me right off the bat. I had great resources available to me through my firm. And I was able to get a will, durable power of attorney, healthcare directives into place, rather quickly. And I was a bit of a trendsetter. I was the first in my friend group to have children. And then shortly thereafter, more of my friends started having kids. And inevitably, I would get these questions about, what happens here? What can we do? What kind of documents do we need in place? And so I wasn't really doing it in my practice, but I was doing it a lot in my personal life, and, giving advice to friends, not really as clients. And then a few of them did want to become clients in that capacity. So it sort of grew organically that way, through me having a young family, and then friends of mine starting their own families and advising them. What I noticed is that it really helped to set them at ease once the plan was in place. And it was genuinely a help for them. And I liked doing it. I liked preparing the documents. I liked the signing ceremony. I liked to answer the questions along the way. And really you can get very creative with estate planning, or it can be very basic. And either way, it's a great act of love for your heirs. It helps them during a time where they're going to be grieving. It helps to guide them. So it evolved that way in my personal life. And now, for the last 2 years it's been, I won't say my exclusive focus, because I do practice in other areas, but about 80% has been estate planning since 2023.
As somebody with two little girls, it's resonating for me. And you touched on a bunch there. We're going to get into some of the documents of what you need, what's essential. But I want to ask you, why is estate planning, and you touched on it a little bit, but I would love for you to go into more detail. Why is it so important, especially for families that have younger children? And why do you think people just put it off?
So I'll answer your last question first. People put it off, especially young families, because, well, number one, you don't have time to deal with anything other than the immediate most days. You're dealing with the morning routine, you're dealing with dinner, you're dealing with what's going on the next day. What are we doing this weekend? And that's just in your personal life, and you have a profession, you have other things that you're doing. So, it's not, no one thinks they're going to die tomorrow. Nobody thinks they're going to become incapacitated tomorrow. So it doesn't feel urgent. So I think it's a very easy, it's an easy thing to put off because it's very easy to just put out of your head, really. But you are likely to face incapacity at some point in your life. Uh, as I believe it was Benjamin Franklin said, the only three certainties are life, death, and taxes. So it will happen at some point, unfortunately. It's not very pleasant to think about. I think that's another reason, and that's perfectly valid. But, despite all these kind of obstacles, and you see it at any age, really, but uh, once you get over that, it can become very, almost mechanical because it just becomes like laying out a plan as you would for anything else. So in terms of why it's important, if the government has default rules that take over if you don't have a plan. So if you die intestate, which just means that you die without a will, then what happens to your estate is governed by statute, which that may line up with your wishes, but chances are it's not going to line up with your wishes. It's the government's best attempt at default rules, but everybody's situation is completely different. So their default rules may not be what's best for your children. It may not be what's best for how you want your assets distributed. And part of the planning process that I really emphasize with my clients, especially with young children, a document is one thing. I can put down that my sister takes my kids, takes custody of my children when I pass away. That's just expressing a preference of mine. My sister is by no means obligated to take custody of my children. So part of the initial, the consultation process, and then even, before the documents are prepared and signed, I encourage all prospective clients or active clients to have that conversation initially with the person that they want to take custody of their children. You want to make sure that they're on board with the plan and that they're not getting blindsided once you pass away with this responsibility. And there's nothing compelling them to take it. So, my own personal situation, my brother's a firefighter, but he's living the bachelor life. My sister has two children living a very similar life to me. We've had that conversation. We know that we're going to take custody of each other's children if the worst happens to both us and our significant others. And that's achieved through a last will and testament. When you're on the younger side, like I touched on before, you're more likely to face incapacity. The documents that deal with that are your advanced healthcare directives, which is sometimes called a living will. I don't love the term because it gets confused with the last will and testament, but living will is essentially your wishes for your health care and the appointment of agents to carry out those wishes and to make decisions in areas that might not be defined by the document that you sign, because there's always different permutations and things like that. And then you have a durable power of attorney, which you can sign to empower your significant other or backup agents to take care of your financial responsibilities in the event that you're unable to. So for young families, it's essential to have at minimum a last will and testament in place, because that's where you're going to make your guardianship designation for your children. That's by far the most important thing, period, stop. Of course, you can also distribute your assets with a last will and testament. The healthcare documents are very important as well, and so is the durable power of attorney in cases of incapacity. But to ensure the guardianship of your children is what you want it to be, the last will and testament is absolutely essential.
And I appreciate you giving us all those essentials for the estate planning documents that the parents need, especially ones with young children. So let me ask you, because you mentioned will, I think you mentioned trust at the beginning of the episode, but can you kind of give our audience a difference between a will and a trust, and how does each one function for families with young children?
Sure. So, generally speaking, most young families are going to use a revocable trust. Uh, Sometimes you'll hear it called a living trust, a revocable living trust, an inter vivos trust. Uh, there's a few different names, but basically, the main distinction between the last will and testament and the living trust is when the document becomes operational. So the last will and testament is only going to come into play when you pass away. So that's when those instructions are going to be followed. Now, and to just there's a bit of a nuance. Last will and testament can create trusts as part of the document. Those are referred to as testamentary trusts. So you distinguish testamentary trust from a living trust. A testamentary trust becomes operational with the directions from your last will and testament after you pass away and after the will is probated. A living trust is put into effect while you are alive and is operational while you are alive. So there are many benefits of a revocable living trust. It is more work up front for you to title assets in the name of the trust properly, to transfer your home into the trust or other assets into the trust. It's more work for you during your lifetime, whereas with the testamentary trust, your heirs are going to use the probate process to get those assets into the testamentary trust. But the benefit that your heirs get from that is they don't have to go through the probate process for any assets that are properly put into that living trust. So for 90% of young families, the largest asset is the primary residence. So just to use that as an example, and one other, kind of nuance I want to mention here is that a trust and a will are not mutually exclusive. So if I were to prepare a living trust for a client, I would also prepare what's called a pour over will. And that's titled the way it is because the pour over will uses the probate process to get any assets that weren't properly titled in the living trust during your lifetime into the living trust. So that's kind of a funnel for any assets that you just didn't title into the revocable trust while you were alive, then the probate process is necessary, but the directions of the trust will still be followed. So, in the example where you transfer the primary residence to your revocable trust, so you own it, with your wife or you own it individually, we draft a living trust and then we use a deed to transfer the property from you personally to you as the trustee for your revocable living trust. And what that document is going to spell out is exactly what happens to that asset and who has control over that asset. Number one, while you are living. Number two, when you're incapacitated. And then number three, after you pass away. And I'm using very broad, umbrella terms. There's virtually limitless things you can do with a trust in terms of planning, but that's really the most important. And it takes that asset then out of your estate for the purposes of probate, meaning as soon as you pass away, that property is going to be under control of your successor trustee. You do not need court intervention for that. The probate process is essentially court intervention to make sure that the asset's passing according to your last will and testament. If your primary residence or investment properties or any other assets that you put into the trust, they don't need the probate process to enable your successor trustee to take control of that asset. It is still countable for estate taxes, the value of it, but the asset itself, the control of the asset, is governed by the trust instrument itself.
Keith, you were mentioning a little bit about the assets front, but for parents that are listening to this, they want to make sure their children are financially protected. What should they do? Like, what in terms of obviously allocating money, 401ks, investments, retirement funds? Like how can they make sure that their children are financially protected if something unexpected happens?
It's a great question. And the first aspect would be to get life insurance. So that's not technically within the estate planning that I would do. It really comes into play just to make sure that the beneficiary designation on the life insurance policy matches with your estate plan, because uh, what some people do know, some people don't, the beneficiary designation on a life insurance policy, on a retirement account, on an investment account, that is what controls where those funds go. Your last will and testament does not control where those accounts go. The beneficiary designation does. So if you have minor children, you would, of course, designate the other. Well, I shouldn't say of course. In most situations, you would designate the other parent as the primary beneficiary and then designate them as a contingent. And then you would spell out how you wanted the funds to be distributed as part of your estate plan. So that could be by leaving the proceeds to your estate and having a testamentary trust govern how the funds are distributed, or it could be leaving it to a trust that you fund during lifetime, could be the beneficiary of the policy, and then distributed by a trustee in accordance with milestones. You can tranche it out. You can have it for their health, education, and maintenance, and then distribute it outright at a later date. But basically, you want to make sure that there's adequate assets to fund what they're going to need. So the best way to do that is with life insurance and to make sure that they have the funds. And then as far as distributing the assets, you have a trustee, whether that's through a testamentary trust or a living trust, that's going to make sure that the funds are used wisely, invested wisely, and used to fund them.
Earlier you were talking about those healthcare proxies and power of attorney. Can you kind of explain a little bit more, not only of those terms, how they work and how they can protect a young family?
Sure. So start with the durable power of attorney. There's different types of powers of attorney, but in most cases, I would recommend a durable that becomes effective as soon as you sign it. There's another type, which would be a springing power of attorney, which would only come into play in times of incapacity. But you really want this in place because if you become incapacitated and you're in that gray area, you're not passed away, you're not deceased, but you're not able to make your own decisions, then any assets in your name, bank accounts, real estate, anything like that, your loved ones aren't going to be able to do anything with those assets if you are incapacitated without the durable power of attorney. So you can limit the powers as much as you want on a durable power of attorney. I typically recommend giving your agent the most power and discretion that the document affords. And the reason for that is you really never know what the exact situation is going to be. And if it's someone that you're designating as an agent, there should really be no doubt about your trust in that person and their ability to function in a crisis, or their decision making from a business standpoint and on financial matters. You really have to have complete trust in that person. So it would be typically spouses designate each other as their primary agents, and then their successor agents in case of simultaneous disaster or simultaneous incapacitation. So when you have that in place, you have your financial house pretty much taken care of, and you have people empowered to act on your behalf if you're incapacitated. What the durable power of attorney does not empower people to do is to make healthcare decisions on your behalf. So that is where advanced healthcare directives come into play. Like I said before, the living will is the better known one. That basically spells out your wishes for specific situations. For the big one is, do you want to be kept alive through artificial means if there's no realistic prospect of a recovery. Most people do not want to be kept alive in that situation, and they want to express that and make it clear. Others do. They take the view that, if I'm kept alive and there's no realistic prospect of recovery today, if they keep me alive for a couple of years, maybe there'll be advances in medical science and there'll be a realistic probability of recovery down the line. So, no judgment either way, but it's something you certainly want to make clear, or you give the discretion to your agent using the advanced healthcare directives to make that decision for you. Because again, if you're in a state of incapacity, we can't ask you. So this is the best way to have your wishes expressed and your loved ones empowered to make those decisions, or just empowering them to make the decisions if you're not really sure what you want in the situation. And again, I encourage broad power, wide discretion, because you don't know exactly what the situation will be. So it's more about picking the right person than anything else, or the right people, I should say.
Keith, let's land the plane on this because we've talked about so much, and there's a lot of people that are probably watching this are a little overwhelmed right now. What's the best way that you would recommend to them to begin creating an estate plan? Of course, obviously, hitting up Pedrani Law to find out more information, but what other ways?
The most important thing, if you have children, is to figure the guardianship out and have that conversation with whoever you want to raise your children should the worst happen to you and the other parent of your children. That's first and foremost. Have that conversation. It's not an easy one, but it's not an easy one to initiate. Once it's started, I think it's a pretty easy conversation. If you're having with somebody who's close enough that you want them to be raising your own children, that should be very comfortable. And once you have the answer to that question, that's by far the most difficult one. Just get a last will and testament in place. You can do it, of course, reach out to me. That would be my preference. We can turn it around. Honestly, a simple will in a couple of days. I've done it same day before with exigent circumstances. And then, I'd prefer that you do it all together, of course, and we go through the process. And, I learn about you, I learn about your family, I make a recommendation, and we complete your estate plan in one shot. But that's not how life works, and not how life works all the time. And you may just want to get the bare bones in place now. And then, later on, when I have more time to think about it, I'll put, then I'll do the revocable trust. Then I'll do, my healthcare directives. Then I'll do my durable power of attorney. I don't recommend putting them off, but bare minimum, get the last will and testament done to make your guardianship designations. After that, I would say the durable power of attorney and the healthcare proxy are secondary only to the last will and testament. Because of the guardianship designation, you're much more likely to face incapacity than you are death as a younger person. So ideally, all three of those at once, bare minimum, last will and testament. And then, if you get the trust done as well, all the better for your heirs. But the guardianship for your children, by far the most important thing.
Keith, thank you so much for the time and insights on this. We truly appreciate it.
All right. Thanks, Mike. I appreciate it.
And thank you to everybody out there listening to today's episode of Straightforward Estate Planning with Pedrani Law. If you're a parent, like I am, like Keith is, you're ready to put the right protections in place for your family, do me a favor right now. Visit pedranilaw.com to schedule a consultation with Keith. Don't forget to leave a review, subscribe so you don't miss the next episode. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.